Thanks everyone for joining us. This is our second of a series of 3 live virtual lectures that we're doing with experts in forensic and legal psychology. We really appreciate you joining us. I know we've got students and staff and faculty from around the country and even around the world. So thank you for joining us, especially if you're in a different time zone that's a little more complicated for you. I hope you're all doing well and staying safe and your families are doing well. It's certainly a challenging time for us. We've certainly mastered Zoom at this point. So we're glad we can use this venue to get out to you and kind of share information. And the goal being that we're not here to talk about Roger Williams University. We're here to really talk to you about forensic and legal psychology. And I guess I didn't really introduce myself. For those of you who don't know, my name is Marcus Hansen. I'm the Director of Graduate Admission. I'm not a forensic psychologist, so that'll be my disclaimer. But I've had the opportunity of working with forensic psychology students for the last 5.5 years here at Roger Williams. And it's just been fascinating to get to know the faculty and the students and their research and the things that they've done, both here and in the field. So, and certainly that's no exception tonight. So I'm excited to have you hear a little bit more about what Dr. DiCataldo can provide to you, because he is a practicing forensic psychologist as well as a faculty member. So he's done a little bit on both sides, both in the field and as a researcher and academic. So we have a lot that he's going to provide for you tonight and hopefully give you some insights, because as we talk to students and even to faculty and staff, forensic psychology is a really jazzy, fun topic, but not everybody knows exactly what they're getting themselves into, because unfortunately things on television in Hollywood kind of give forensic psychology a little different bent than what reality is. And so I hope that this session and our other session next Wednesday will give you opportunities to kind of get some insights into forensic psychology. I just want to briefly introduce our guest expert tonight. It's Dr. Frank DiCataldo. He's a professor of psychology here at Roger Williams. He's worked as a practicing forensic psychologist for the past 30 years and has consulted to attorneys, juvenile and adult courts, and state departments of mental health, correction, and juvenile justice. He earned his PhD in clinical psychology at St. Louis University, and his research interests include forensic mental health assessment, juvenile homicide, and the clinical training of forensic mental health professionals. He is the author of the book, The Perversion of Youth, which was published by NYU Press in 2009, as well as numerous articles on issues related to juvenile justice. And I'm excited to have him talk to you not only about his work in the field, but also research related to the Miller case. And I've seen a few of his students that have come out of that work that are now in PhD programs. So there is really proof in the pudding on how this research goes and what students are doing ultimately after our programs and as practicing professionals. So without any further ado, Dr. DiCataldo, take it away.
Thank you, Marcus. Can you hear me? Am I coming through okay? I just want to check.
Yep, sound great.
Okay, terrific. Well, thank you for that. So I want to thank everybody for joining us today. It's a real pleasure to be able to kind of informally talk a little bit about my work as a forensic psychologist and some of the conjoint research I've done with students. So as a way just to build a little bit on the introduction that Marcus gave, I kind of have a double life. I always feel like I spend a large part of my professional time at the university teaching and mentoring graduate students, and it's a very rewarding academic life. I really enjoy it. I've been there for 15 years, but the other half of my life is I'm a practicing forensic psychologist. When I'm not at the university, I'm usually somewhere in Massachusetts or Rhode Island at a juvenile detention center or a state prison or a house of correction, because I have a pretty active forensic private practice, which, as Marcus mentioned in the introduction, I've kind of cultivated over the last 35 years. And I often say this to my students, I'll say it to you. I really like my job at Roger Williams. I mean, if you visited the place, it's a beautiful campus. It's in a beautiful setting. The students are very nice to work with. They're always sort of eager to learn. But if I had to make a choice between being a practicing forensic psychologist and being an academic psychologist teaching at Roger Williams University, there'd be no choice. I would put the university in my rearview mirror because I just find my work as a practicing forensic psychologist to be so intrinsically interesting and fascinating and just rewarding. So thankfully, I don't have to make that choice. I can sort of have both. But if I had to make a choice, it really wouldn't be a very difficult one for me. I would put the university in my rearview mirror almost immediately because, and I often say, I've done this for 30 years, being a forensic psychologist. I could do it for 300 years. I mean, I just find it that intriguing. And every case to me is like a little puzzle to be solved. So most of my comments today are going to be about my life or my work as a practicing forensic psychologist, because that's who I am, really. I am going to talk about some research that I've done, but the research is really kind of informed by my practice. It's my practice and sort of the practice problems that I encounter that kind of informs my research. And that's sort of how the field, I think, works. When it works best, it's this kind of reciprocal exchange between practice and research, research and practice, research informing practice, right? I want to make sure that my practice is evidence-based and I'm making and utilizing all of the science that's available, and that I'm integrating that into my work. But also, you know, things that are coming up in the field, you know, current issues in the field, current problems in the field, really need to kind of come back to the laboratory, if you will, to be worked on. So it is this kind of nice reciprocal relationship between the two. My clinical practice is pretty broad-based, and I'm going to tell you about a little specific sort of specialization that was unanticipated. This is not something that I, you know, aspired to or had a plan for. It just sort of kind of a door that opened for me a number of years ago. I've always had the joint interest in adults and juveniles. I've always sort of had my foot in both worlds. And I actually think that that's a good thing because each informs the other. But unexpectedly, in around 2015, actually 2012, there was a case by the U.S. Supreme Court called Miller v. Alabama. And this is actually the third of a series of U.S. Supreme Courts that specifically addressed the issue about the culpability or the blameworthiness of juveniles who had been charged with murder. And you know, I'm not going to get into the holdings of Miller, but just to sort of spell them out for you broadly, for those of you that aren't familiar with it. It basically held that it's unconstitutional under the Eighth Amendment, which is a cruel and unusual punishment. It's unconstitutional, essentially illegal, to convict juveniles to life, to automatic, and the automatic's an important part of the word, people get confused, to automatic life without the possibility of parole. That's impermissible. It's unconstitutional. And the U.S. Supreme Court lays out a number of sort of factors, but the basic sort of theme of it is that youth matters, that by virtue of their youth and their developing status and newer research around, neuroscience research around the adolescent brain, that doesn't excuse juveniles. That's not what the U.S. Supreme Court says. It doesn't excuse them from punishment, but it certainly is a mitigator. Youth matters, and it should be something that is considered in any kind of sentencing schema. And so what the U.S. Supreme Court said there is that you can sentence a juvenile to life without the possibility of parole. A court may do that. It doesn't exclude that, but it can't do it automatically. They have to do it on a case-by-case basis by looking at the life of the juvenile, the circumstances of the offense. They really kind of put everything in there. Anything that's worth looking at, they sort of include it. But it has to be this individualized decision that's made by typically a judge, but it could be made by a jury as well. Um, and you know, you don't think sometimes that a U.S. Supreme Court has you know, to me, it sort of brought home how profound an impact a U.S. Supreme Court decision can have on the ground, because suddenly, as you can see here in the slide, in the first bullet point, there were about 2,500. This was not a, you know, that's not a huge number of people, but there were 2,500 people across the United States who were serving essentially an illegal sentence. They had been sentenced to life without the possibility of a parole for a murder that they had committed while they were a juvenile. And essentially they were, unless they were going to be given a governor's commutation or a pardon, they were basically sentenced to die in prison. And then suddenly, you know, in one fell swoop, they were now provided with a meaningful opportunity. It doesn't mean they're going to get out, but they were now provided with a meaningful opportunity to make their case to a parole board or to a resentencing court or a judge that they indeed had rehabilitated themselves, that they were no longer the person that they were as an adolescent, and that there was a window for them or a reason for hope. So where do I come in on this? Well, you know, in Massachusetts, there are Miller cases. There's been some discrepancy about how many. Some say 57, some say as many as 65, not a huge cohort. Rhode Island does not have any Miller cases because their sentencing schema, pre-existing sentencing schema did not allow for the sentencing of juveniles to life without the possibility of parole. But there were about 60 or so individuals in Massachusetts. Now, the Massachusetts Supreme Judicial Court in 2015, so this is 3 years after Miller, they did the U.S. Supreme Court one better. You know, sort of the U.S. Supreme Court sort of sets the floor, sort of the constitutional floor. You know, you can't go any lower than this, but that doesn't bar any states for providing more rights or for individuals. They can go beyond what the U.S. Supreme Court grants. They just can't go below it. And Massachusetts Supreme Judicial Court in 2015 did the U.S. Supreme Court one better and effectively banned life without the possibility of parole. Prospectively, that is, in the, you know, for cases now and in the future, they basically abolished that sentencing schema, but they also applied it retroactively. And one of the sort of more interesting sort of ironies about this, and I'm sure that this wasn't done intentionally, they issued their finding on December 24th of 2015. Can you imagine? Can you imagine? Put yourself in the position of an individual, one of those 60 individuals who may be in prison. You've been in prison 10 years, 20 years, 30 years, 40 years. Yeah, you know, you're 55 or 60. There's no, suddenly a correctional officer walks down the tier. I've had men tell me this. Walk down the tier and just slips a piece of paper under your cell door, and you open up the piece, and it's your parole hearing date. You've been given a parole hearing date. You could just see the dramatic on them. So since 2015 or so, I've been retained by mostly defense attorneys, sometimes the parole board itself, to conduct parole evaluations. And I've done, you know, probably about 25 or 30, maybe about half of the men there. And I have to tell you, these cases are absolutely fascinating to work on, because a lot of times you're working on a case that's 30 years old. Sometimes it's as little as 20 years old, but sometimes it even goes back to 40, men in their 60s. And it's a little bit like investigative journalism. You're really digging back into the, you know, and trying to kind of recreate the circumstances of the homicide. You're also sort of looking at their prison adjustment record and using psychological tests, interviewing third parties like their family, and producing a report, and ultimately, not always, but sometimes testimony to the parole board about whether or not this individual is at a level of risk that their risk has been reduced, and that they've been rehabilitated such that they'd be eligible for parole. So that has become a predominant sort of, and like I said, that was unplanned. It was just something that the U.S. Supreme Court did that I got kind of roped into, and I'm sort of glad that I have. And one of the more gratifying aspects of that is that I bring the graduate students with me to these cases. The inmates are very generous about that. They understand that these are students, that they're learning, they want to be psychologists, they may want to do this kind of work in the future. I've never had an inmate say no, never. They're actually eager to talk about themselves and to sort of present themselves. I never had an attorney say no, as long as the student understands that they're operating under, you know, attorney-client privilege, and that's never been a problem. So I take the students with me, but there is a quid pro quo. There's no free ride. They have to do some of the work. So I usually have them do some of the testing and score the testing. I usually have them do the record review. And I do the interview, of course. I don't have the student do the interview, but they observe the interview. And they're really there, you know, and see the whole process of kind of putting a case together. It's a massive effort. It's many hours. It's usually a long report, 20, 30 single-spaced pages. And I write the report, but they get to see how that goes. And then they come to the parole hearing. They can sit in the parole hearing. These are open to the public. And they can come in and sit at the parole hearing. And I think it's been very rewarding for them. So out of that, it brings me to my briefly, my presentation today is I've done a number of thesis projects and even just some more informal projects with students on this database, And to date, I think I've done one or two thesis students. I've got currently a student working on another thesis, because this database is constantly being updated and accumulated, and has resulted in some presentations at conferences, and one conjointly authored publication. So that a couple of graduate students that did some of the, helped me with the data analysis and helped me with writing up some of the method sections. We put together a manuscript that was accepted for publication, and so it's a newer kind of area, but it's certainly one that I think, as you're going to see, hopefully is one that I think is very fruitful. So let me sort of talk now more about the research end of this, and I'm going to do this pretty quickly because I want to leave some time for questions. So what can we say about this cohort of individuals, these juvenile lifers? Well, there's been some national kind of studies around the demographics of them. And this comes out of Nellis 2012, which looked at a national sample of them. And, you know, just sort of looking at some of the characteristics that would define this cohort. And I think any of these sort of bullet points would not surprise anybody. There's a high level of exposure to early trauma and adversity in their life. That shouldn't be surprising. They've had a number of significant educational challenges, and they are often significant social and economic disadvantages. These are typically individuals that have accumulated a significant number of early adversive experiences. I think that gets them on this pathway. Law Center here in Massachusetts, who I've done some work with, look more at the 57 to 65, and it's the same kind of thing. I think what's interesting here in terms of their offense history, I think is what's surprising, is that these are often not individuals that have a long track record of offending. A little less than half are serving time for murder. It's their first offense. I mean, it's just sort of like they go from 0 to 60, which tells you a little bit about, I think, often what the circumstances of these are. 20% are serving juvenile life without the possibility of parole for a felony murder. And felony murders is like sort of an armed robbery gone bad, or a drug deal gone bad. And it's about 80% of them are kind of conflict-based, that they're peer on peer, or some family-based homicides. So the fact that they're only 1 in 5 are kind of felonies sort of tells you something about that. These are often very emotionally driven and not sort of opportunistic kinds of offending. A little less than half had 1 or more adult co-defendants. Now, you know, those adult co-defendants could be anybody over 18, so somebody 19 or 20, but usually, generally, compared to adults, what's sort of a hallmark feature of a juvenile homicide is that this is done in a group. This is a peer enterprise that's compared to adults, which, you know, which is sort of typical of adolescents, right? And as you can see, the rest of the sort of early adversity that they had. So let me tell you a little bit about the research literature on the recidivism of juvenile homicide offenders. And there's been not much. These are just some of the studies. There are probably a few more that I could have updated, but there's really only been a handful. And you can see the recidivism rates are really quite variable. I mean, they range everywhere for, in terms of nonviolent reoffending from, low of 40% to a high of 60%. And for violent offending, a low of 20% to about 35%. But it's not certainly not the case that they all reoffend. These studies are, I think a reason in publication for the great variability is that, as you can see, they use different definitions: conviction, rearrest, reincarceration. In terms of your recidivism measure, that's going to change your rate, right? If you're going to use arrest, that's going to be a larger pool of individuals versus using reincarceration, excuse me. And also follow-up years. You know, if you're going to use a 1 to 3 year period as opposed to a 15 or 8 year period, that's going to have an effect on how many parameters in terms of how they define things. Let's tell you a little bit about our study. This study came out of an initial study I did, DiCataldo and Everett. These were 33, we had 33 individuals that were awaiting trial for homicide offense that were interviewed between 1995 and 1998. This was a sample of juveniles before I was at Roger Williams University, when I was consulting to a detention unit which housed juvenile homicide offenders. And we did a study where we interviewed 33 of the juveniles, and we compared them to 38 not violent but non-homicide offenders. So we had 33 juveniles awaiting trial for murder and 38 juveniles that were awaiting trial for a violent non-homicide offense. And in the DiCataldo Everett publication in 2008, we reported on the differences between those. And you know what we found? Not many differences. One of the big differences we found were that the homicide offender reported that a gun possession was a regular part of their social milieu. So it was easy for them to acquire guns. There was guns at home. So it was guns and drugs that really seemed to differentiate the murder from the violent but non-homicide offenders. We did find that the violent but non-homicide offenders often had, at a statistically significant rate, more serious offense histories. They also had a more serious history of mental health problems. So in many ways, they were higher risk. The sort of paradoxical effect here was that it was the violent non-homicide offenders that, on standard risk assessment measures, would have come out as higher risk. So what did we do in the new study? Is that we took those original 33 that were archived in a box in my basement and brought them up, and we asked the question: what happened to these kids? Well, they're not kids anymore, right? And we found in our research that 22 of the 33 had been released to the community. They were out, and we were able to get a CORI, or criminal offender record information. So we knew that one had died in prison. About 10 were still in prison, and that 22 had been out. They'd gotten out either through parole, or they were sentenced under a sentencing schema that had been a prior sentencing schema where they were given a sentence of like 10 to 15 or 15 to 20, and they were out. So we asked the question, what happened to them? We were interested in how many of them recidivated. So we use these definitions. So it's a simple study. I mean, I don't want to oversell it here. But sometimes the simple studies are the best studies. We were just interested in a simple question. Of these 22 individuals that had been convicted of a homicide while they were juvenile and had spent a significant period of time in prison and had been released from prison as adults, what was their outcome? Okay. And we use this set of definitions based on the literature. We came up with a 4-definition schema. We labeled individuals as serious, violent, persistent offenders if they had been post-release, there were 2 or more post-release convictions for a violent offense, or 1 violent conviction involving the use of a weapon. It's just an operational definition, right? We labeled individuals as serious, violent, persistent offenders if they had 2 or more convictions for a violent offense, or they had 1 violent conviction involving the use of a weapon. We labeled individuals as single violent persistent offenders if they had had 1 post-release conviction for a violent offense without the use of a weapon. So it would be like sort of an assault and battery, or a fight or something like that. We labeled individuals as violent desistance offenders if they had 1 or more post-release conviction for a non-violent offense, right? And they had no violent offense convictions. Those were our violence desistance group. And we labeled our total desistent offenders that there was no post-release criminal convictions. In other words, their criminal record was clean. All right, so we used those 4 definition schema, and then we searched their CORIs, and here's our findings here in the next slide. What we found was that, and I'm reading here from right to left, so let's start with total desistance offenders. Look at that. We found that 15 of the 22, which is 2/3 of the individuals, had nothing on their CORI. All right. This doesn't show any down here, but you're going to find that they were out in the community about 8 years. That was the average length of time that they were out. They were free. Our follow-up time was about 8 years. All right, moving along to violence desistent offenders, we found that there were 3 individuals, about 13% of the sample, who had things on their CORI, their criminal record, but nothing for violence. It was something else, maybe a drug charge, or maybe a trespassing charge, or something else, but it was a non-violent offense, and we defined violent offense for the study as a person offense. Moving along, we found 2, or about 10%, that had a single violent offense. And then further on, we found that there were 2 individuals, and I actually know, and the funny thing is I know who these guys are because I was on the unit and did the interviews with them. And not that this means anything, but it was no surprise to me who the 2 were, who were serious violent persistent offenses. That is, they had 2 or more violent offense convictions, or 1 with a weapon. So, sort of looking at this, what you could say is that 2/3 had nothing on their CORI. You could also say that about 80%, or 4 out of 5, after 8 years of freedom in the community, had no violence. We didn't really find, the sample, probably one of the difficulties of the samples is so small that we're really able to do kind of inferential statistics on it, excuse me. But let's look at some of the other sort of variables here. So we really couldn't run kind of inferential statistics. The numbers are too small, right? It's a problem with a small sample. But nonetheless, if you sort of look, the average age at the time of the offense was about 16. That's no surprise there. That's who we recruited. We recruited juveniles, so that the fact that they were 16 years old makes perfect sense. Their age at release was about 28 to 29 years old, which I find fascinating because it's completely in line with the research on adolescent brain development, which shows that many of these men, when they were released just past the sort of the crescendo for their high risk phase of life, right? It's usually around, if you look at the age crime curves from criminologists, it's just sort of held up study after study. It's been held up across culturally, it's held up historically, that, you know, crime begins to precipitously decline in the mid-20s. I always find that fascinating because it's the exact same time. I don't think this is coincidental, although it'd be hard to make causal statements about this. That's about the time that the neuroscientists say that the adolescent brain is kind of fully developed, the frontal lobes are kind of on board. So that it's those two curves. If you put those two curves and superimpose them on each other, it's basically the same curve, and that's what we find here. These individuals are released past the high-risk time of their life, and from a public policy point of view, that probably makes sense that they're put on ice, if you will, during a high-risk time, and that and then, in the late 20s, early 30s becomes a time when it's they're lower risk, and you wouldn't really need to keep them 40, 50 to their age 40, 50, or 60 from a public safety perspective, not from a retributional perspective. If you're a retributionalist and feel like, eye for an eye kind of thing, well, that's a kind of conversation no starter, and I understand that, but that really wouldn't apply here. And that's not what the U.S. Supreme Court said, right? The U.S. Supreme Court said that youth matters. So, and as you can see, the time at risk, they were about 8 years, not much difference there. And then I have here some of their criminal history. And as I was preparing, I probably should have, I get the ends here, how often. Probably should have reported these as a ratio. In other words, I should have put this N over the number of, this was like prior offenses, 68, over 2 and 2. So I go to comparing these sort of ratios, because when you use these sort of ends or these raw numbers, it's hard to make these comparisons. But so let's look at some general conclusions here. Major findings: recidivism rates utilizing post-release convictions were generally lower. So our study, again, it's a small sample, but our recidivism rates were generally lower than in previous studies. We conclude or hypothesize, I think probably a better word to use, that these lower rates may be due to their older age, that the average age of release was 29, and that they had served an average of about 13 years in prison and had been in community for about 8 years. And some general things about the groups: the total desistent offenders, which was like 68%, had the least criminally involved. When we looked at their family histories, had the least criminally involved families and reported a lower crime problem in their community. But they reported feeling less safe than the members of the other group. Remember, this was done in 1998. So it's interesting. These individuals come from, they report a lower crime problem in their community, but they report feeling less safe. So of violence than some of the other ones that came from higher risk or higher crime neighborhoods, but they were less worried about it. That, to me, that seems like that's problematic. This is a better situation. They also had fewer prior mental health and substance abuse problems and fewer problems with anger control and fighting. This is mostly self-report, so you have to take that with a grain of salt. The violence desistent offenders, they occupied a kind of a middle position between the two more serious groups on prior delinquency, family history, mental health, and community variables. So they were kind of the mean between the two extremes. And the serious violent persistent group, which was again only 2 individuals, but nonetheless they had compared to the others, had a more significant history of family criminality, more severe mental health and substance abuse problems, and they reported more problems with anger control and fighting. Obvious, limitations of the study. It's a small sample. You got to be very careful about your generalizations when you're using a small sample such as this. But nonetheless, I think that they're worthy of discussion and presentation. There is a selection bias here. It happened to be 33 individuals that came to that unit at that particular time. So we really don't have a community sample. It'd be very difficult and identify these 22 individuals, probably more than that now. I know them. It's been many years since I've seen them. My hunch is that they would be open to talking about their post-release life. That would be a fascinating study to do, to interview these men and to sort of have them talk about, and from their own perspectives, what were the key turning points? Because these are successful men. You have to admit that as far as we know, they've not reoffended. So we would count that as a success. I want to find out what are the ingredients of that. How do they explain that? Is it about social support? Is it about spiritual things, values, or church? I don't know what it is. Work, employment, but there was something that distinguishes them from the other group. And I think that would be an important thing to know. And that would require a lot of legwork, finding them and then going to interview them. But it would be a terrific thesis project for a couple of students that wanted to work on that. I think these have some obvious implications for resentencing hearings. It also talks about the potential for it's totally in line with the U.S. Supreme Court. They did a great job. I totally agree with that finding. And Elena Kagan wrote a beautiful for most that commit the things that adolescents do that adults would never contemplate. It really has to do with the fact of their adolescent status. And really the protective role of normal developmental maturation. Well, is sort of what's the key to desistance? Getting older. There's not much good about getting older as I'm getting older, but one of the good things about getting older is that you're less risky, less violence prone. So I think one of the key sort of things here is nothing more magical and stupendous and ephemeral than just normal maturation, getting out of sort of that adolescent sort of phase of life. Well, with that, I'm going to conclude, I think, my comments, and I want to thank you for your attention, and I'll take any questions that you have.
Frank, that was great. Thank you. And I know I've had the privilege of hearing some of this previously, and it was always fascinating. So I'm glad the students get to share in that. If anyone has any questions, please enter them in the Q&A box there. And I think, Frank, I'd love to hear more about how you can connect that work with actually influencing policy and kind of regulatory outcomes. Can you take that to legislators? Granted, you only had an N of 22 or so people, but as this expands, is there opportunity for you to then influence actual policy outcomes either at the state or federal level?
It's funny you should mention that because yes, I've had, I don't know the impact of it, but I have testified at at the State House in Massachusetts. I did not present these particular findings because they didn't exist then. But, you know, the Massachusetts State Legislature has been involved in some new legislative efforts to kind of raise the age of juvenile jurisdiction. So raise the age at which you end up in juvenile court. I think there's a lot of research that would support the idea that that's probably a good idea with the adolescent brain development, so that if you were 17, you would be in adult court. I think that's ludicrous. Now, if you're 17, you're still in juvenile court, and then moving towards even including 18-year-olds. And I think the research would support that. But generally speaking, adolescents that are processed and treated within the juvenile justice system have better outcomes than similarly situated juveniles that have been processed through the adult system. So there's been some opportunities for that. I've just had an opportunity to meet with the head of the public defenders unit in Rhode Island, and I'm going to be doing some trainings, presenting this research, and I actually grabbed a couple of graduate students. They're going to do the training with me to the all of the public defenders and prosecutors. And prosecutors are on board this, so we're doing that in December. And I'll be presenting this study and others. Now, whether or not that'll have any impact on public policy, I don't know. But we're going to be sort of talking about how to use some of this research in trial and hearings. And then I'm also meeting with a state legislator in Rhode Island to talk about this stuff. So your question's a good one and timely. So yeah, there seems to be, you know, some interest at a public policy level about how to kind of implement some of these changes.
Great. And Frank, your microphone was a little muffled there. I don't know if you have anything that's like against your computer or not, but it was kind of blocking you a little bit.
Okay.
So we got a flurry of questions since we started talking there. So I'll pose them here. Have you been able to observe any gender differences in whether or not a juvenile will receive life without parole sentencing?
That's a great question, and I didn't mention this. I could probably because I assumed it was would be obvious, but it's probably not. There was no girls in that study. Those are all boys, and of course now men. But you know, I've done juvenile homicide cases for girls, but they're pretty rare. I think over the course of my 35-year career, maybe 3 or 4. So, you know, just I could talk anecdotally that I don't think there's much, you know, that there probably are some differences in those, but not, I think one of the major differences that I found in just the cases I've done is that the girls have a lot more trauma. They're a lot more trauma and mental health issues in their backgrounds than the boys. But there's probably not been enough cases, at least in my sense, in my experience, where I can sort of look at that more systematically.
Right. Now, here's a question here. You said you weren't surprised by the 2 repeat serious offenders. Why was it not surprising that those 2 individuals reoffended to that extent? And what is done to assess that risk ahead of violent offenses being committed?
Well, I mean, it's just that I remember those 2 guys on the unit. I would say that they, you know, I don't know if this is sort of more confirmatory bias on my part, you know, kind of a hindsight bias as well. But I recall them on the unit being having more maladaptive personalities. You know, they're a little bit more disagreeable and more detached. So I would characterize them as having some personality features that were consistent with psychopathy. I'm not saying psychopaths. I don't know. I didn't assess them for that, but they certainly on the surface seemed like they had more entrenched maladaptive personality characteristics that I think the literature has indicated have been more correlated with life course persistent offenders. So now what you can do about that, I mean, I don't know. I mean, there's ways to intervene in terms of that, but I mean, these guys were serving sentences, so I'm not sure we were in a situation where we can their sentences or something like that. But there probably could have been way, we didn't do this at the time, but there probably are ways that we can assess them for that, those personality features and try to intervene more strenuously.
So there's a question specific to the recidivism piece. Do you think that these successful individuals, the ones that were more kind of acclimated back out and successful, could help explain what works with reducing recidivism in a generalized convicted population?
Yeah, I think you can generalize from that. I mean, I do think I do think it's probably, I don't know for sure, but I think it's probably key to desistance. I think the key to desistance for this group is probably not that much different from the key to desistance in general offending. There's those tried and true protective factors that we know about. And one of the big ones is employment and economic opportunity and social support. Those individuals that are being released to supportive environments, they have family, or they have communities that support, are gonna make a better adjustment. I would hypothesize that's true of this cohort, just as it is for the general offenders. So I don't think there's anything going to be anything that's all that different from these guys than we know about this group of general offenders.
There's a question here related to legal psych a little bit. I think certainly Dr. P would be probably one that would have some opinions on this, but in your experience, Frank, how different are jurors' perceptions of the death penalty for juveniles versus adult offenders?
We don't, I don't have any practical experience. They don't have the death penalty here in Massachusetts. And I myself, I've never worked on a death penalty case. So, but I do know a little bit about the research. This is a question that has been addressed in some research, and the general public, I think, or prospective jurors, I think, buy into the U.S. Supreme Court. I mean, the U.S. Supreme Court said youth matters. That shouldn't be a surprise to anybody who's a parent, anybody that's a coach, anybody that's a teacher. Kids are different. They're not little adults. Anybody that's ever lived their life knows that as an adult, they're not the same person they were at 16. So I think for jurors, they go in there with that same mindset that juveniles are not as culpable as adults. And I think the research has borne that out, that they're less likely, or that they do provide a youth discount. I think jurors come equipped with an idea that they're going to provide a youth. Any other questions?
Oh, sorry, we lost you there, Frank. You froze for a second. Yeah, so there's a couple more questions here. So one's related to your work with grad students. Actually, both of them are. So one is, how would you describe your mentorship style, and what do you look for in a graduate student doing this type of research?
I think of all of the things that I do at Roger Williams, it's the mentoring relationships that I think are the ones that I enjoy the most. I mean, I like being in the classroom. It's not my natural environment, but it's that more one-to-one. Because I'm so excited about this. I mean, I enjoy this work. I find it challenging, and I find it intrinsically interesting and fascinating. And I don't always have all the answers. It's these cases are complicated. So, I mean, I really like a graduate student that has that same openness to that they're open-minded about this. And I like when their views are challenged and they're able to change. One of the most rewarding things is to go into to read about a horrific case, go and meet the individual, and then come out of that 2-3 hour interview, and I'll say, what do you think? And you can see that the student is genuinely perplexed, right? There's a dissonance, what they read and who they met, and they're trying to sort of put the two things together. I find that that's an interesting sort of problem uh, that they come to sort of resolve for themselves. So I think what I look for in a student is someone who has some passion about the work. They want to work hard. They're driven about it, and that they're open. They have to be open-minded. And and my mentoring style is, very informal and unstructured. I mean, it's sort of, whatever they're up for, well, they can come along for the ride.
So a related question then, Frank, do you allow grad students to have any input on any new data you collect? For example, as you're updating the data set, adding a variable for adverse childhood experiences or trauma.
Oh yeah. So yeah. So these cases are very rich. They're very data rich, and they're archival. So there's always an opportunity to expand the database. It does require a little bit of sort of archaeological digging. You really got to be able to sort of dig through the file or dig through the report to kind of pull those out. But yeah, if a student has a research question, that's a legitimate one. Sometimes the research questions just aren't valuable. I mean, I can give you some examples that I try to steer them away from those that I think would be unproductive avenues to go. But if it's a productive avenue that there's a literature that would support it, I'll take them up on it. So yes, it's their project. If it's their thesis, it's their project. They got to design it. So I'm there to kind of help them shape it, but it's their thesis.
So here's another question. Is there a difference between repeat offenses in juveniles and adults? For example, does the repeat offense, the severity of the repeat offense differ based on their age?
Yeah, great question. I mean, I do think that, the way that I would approach it is a little bit differently. I do think that when you have an adult offender, when you're working with a juvenile offender, they're as they mature and they get past that sort of high risk time of life, you're going to expect that their offense history is going to decline. If you have someone who's offending after that high risk time of life, in other words, they're in their 30s and they're in their 40s and they're still offending, that's an animal of a different sort. I'm using that metaphorically, obviously, but that's a person of a different sort, right? Then you're sort of looking at more sort of what are the maladaptive personality characteristics that are fueling this offending. So I think when you're talking about juveniles, you're thinking about a lot more room for growth and change, so that the outcomes are still relatively open. And when you're adults, I think that window for intervention is closing, but never entirely closing.
So Frank, as one question that I think I'd love to have you help with as I talk with students is one of the big parts of your job is report writing. Because I talk to a lot of forensic folks and they love that idea of being in, physical settings and doing the applied work. Can you speak to kind of the necessity of the report writing and that's just kind of a part of the job?
Yeah, that's a great question, Marcus. Thank you. Yeah, so you're absolutely right. Report writing is a big part of the job, and your comments in the early part of the introduction was, you should know that as a practicing forensic psychologist, I've never been on a private jet flying to a crime scene. I've never had that happen. Most of the times I'm in my car and I'm driving to a prison or to a jail, and I actually like those settings. I find them to be interesting. But a lot of my time on these cases is spent alone in my office on days off or in the evening, writing reports. And That's the only thing you have as a, that's your product. That's your work product, is your report. And that's the thing that's going to be memorialized and will be part of the record. So I think I've often tell this to students, if you like this work, you're going to find it's, because when you write a report, you're alone. So a lot of it is sort of a time alone in front of your computer and writing a report. I enjoy that. I mean, there are days that, I would be honest, there are days that it's a drudgery. I'm not going to sugarcoat. There are days that it's like, I just don't feel like doing it. But there are other days I find it very engaging. So you've really got to like, because what you're writing is a story, right? You're trying to pull together the story and within certain parameters, right? You're making it, it's not like short story writing or writing a novel. You're telling a story within the parameters of a clinical report, right? So you're following some rules about that. But basically, you're trying to kind of shape the story of this individual's life. And I just really enjoy that. I really do. But it's, if you like that, if you want to do this work, you really got to be sort of introverted, a little bit more on the introverted. You got to like to be alone a lot because I don't know if that answers your question.
Yeah, thanks, Frank. Yeah, you froze up there at the end, but we got it from you. And I had a great opportunity to talk with some students from North Carolina Central University yesterday, and one of them just had a great question I wanted to pass along to you. If you could recreate the study that you had done, that recidivism study,
Yeah.
and you mentioned the limitations of the small n that you had, but what factors would you include or change, she asked?
Well, that's good. I mean, part of the problem is that the interview that we did in the 90s, I probably didn't do justice to that. There's more there. That interview, form was over 20 pages. So, and these interviews took a couple of hours to do. So I have all this archival data. It is very in depth. It goes into their family, their school, their relationship with peers. All that stuff is there. And it's there. It's in a box, and it could be taken out and recoded and put into a database. So I guess what I'm saying is it's a very rich source of data, and other than the end, which I have no control over, be made up.
So Frank, I got to ask you, you mentioned that there were 57 men, I believe, in Massachusetts
Yes.
post-Miller that were impacted by the Miller case. Do you know how many of them may have been paroled at this point?
No, that's a great question. I don't know that answer. I don't know that answer. I do know that, looking at it sort of nationally, anywhere between 10% and a third get parole. So I do know this, and I've often said this, out of that 57 or 65, whatever it is, eventually my sense is all of them are going to be released, virtually all of them. There's probably a handful that will never get released. Their crimes are so horrific that it's hard to get past that their prison record is a disaster, and no parole board's ever going to let them go. But I think that's a really, really small number of guys. So most of these guys don't get out at the first crack. Usually parole boards are very conservative. You got to earn it, and so it might not be until the second hearing or the third hearing, but you can actually see, they might get a setback of 4 or 5 years. The second time it's 2 or 3 years. Third time, so it's really like it's more of a process than a discrete yes or no.
And we had one more question come in, and I know we're a little after 6, so I appreciate everybody. Well, I guess we'll just wrap up with this last question. But Frank, can you speak to, and this might be a longer answer too. So can you speak to how your experiences in court have been? And this particular student, he said he's curious about your cross-examinations for expert witness testimony.
Yeah. All right. So with this project here, there's not much. Well, there's not much testimony. I only, so my report goes in, and sometimes I'm asked to testify at the parole hearing, but at the parole hearing, there's not cross-examination. I would just get up. I'm given a few minutes, maybe 5 or 10 minutes, kind of highlight the major findings of my report, and there may be a few kind of questions that the parole board asks. I wouldn't characterize it as a grilling or a grueling cross-examination. They're really just kinds of questions that they have, that they might have about the report. So I think it's kind of a light kind of cross-examination. So in this kind of setting, the parole setting, it's not like, it's not as adversarial as a trial. Now, my other work where I'm doing, you know, trial work in actual trials, well, then it gets a little bit more heavy, and but that's just a different venue.
Can you speak to that at all, Frank? Like, are you doing any work with like insanity defense or fitness to stand trial and so on?
These would be insanity cases. Yeah, these might be insanity cases. I'm doing them, I do a number of those. I'm always working on some insanity cases. They may be cases about whether or not an individual needs to register as a sex offender. It may be whether or not a forensic patient can be released from a hospital. Um, um, or it may be at a sentencing hearing where I'm talking about various kinds of mitigators, and it's the trial is over and now it's the sentencing phase, and they're trying to decide on the level of punishment, and I'm there presenting aspects of mitigation. So it's under those conditions, I think, where it's a live trial and you're getting a lot more. And I typically, I'm doing, not always, but typically, I would say about 80%, maybe more like 90%, I'm doing this for defense, maybe about 10% for the prosecution. I don't get called by the prosecution as much. But it's under those conditions on an insanity trial or a release decision where you're getting a lot more grueling questioning.
Okay. Well, and I guess we'll just close with this, Frank. If students are hearing what you're saying and the work that you're doing, and they're going, wow, that's what I want to do. And I know we've got a lot of undergrads on the call. We've got some advisors on the call. What's your advice to them for those next steps to get to where you're at?
Well, I think what I would recommend is, to be a forensic psychologist, you have to have a doctorate. I mean, I think if you're interested in just working with inmates, and I don't mean to downplay that work, it's very important work. If you're interested to be a therapist and to work in a correctional setting and to, be in the trenches and really making meaningful change in the lives of the individuals, you really don't need a PhD or PsyD. You can get a master's degree in counseling or a master's degree in psychology, get licensed, and work at an agency or work at a facility. And but that's more for treatment and intervention. If you want to be a forensic, that is, if you want to do the evaluation, if you want to do testimony, you really do need a doctorate to do that, although, for the most part. But I think there are multiple roads to that place. I mean, I think students sort of, get fixated on the PhD. As they know, and some of the advisors might know, that these PhD programs are very popular. They're very competitive. And they're really in the market for trained scientists. But if you're a person that just wants to roll up your sleeves and just do practice and maybe do some research like I do, but yet you're really self-definition is one as a practitioner, and I think a PsyD is probably something you could look at. I mean, there's no research to suggest that PsyDs make less money than PhDs, or that PsyDs are not as good at diagnosis or not as good at testimony. There's no research to support that. PsyDs, program professional school, it's a professional model, so they're going to be more expensive. than a traditional PhD program. But I think you also realize you're not in school as long. So the typical study program is about 4 years, and you're going to be out practicing and earning um, sooner than you would if it was a PhD program. So most of the undergraduates that I interact with at Roger Williams aren't aware of this. I mean, they just have PhD on their mind, and it may be a PhD is the right degree for them if they are more interested in scientific training. But a lot of students aren't. I mean, most psychologists aren't scientists. Most psychologists are practitioners. And for those that really feel like, the life of a practitioner is for me, they really need to think about a PsyD program.
That's great advice. Thanks, Frank. I talked to a lot of students about that, and they're always kind of on the fence. And you're right. A lot of them have like PhD in the brain and nothing else. And it's good to think
Yeah,
about those options.
yeah. I mean, I think, yeah, PsyDs, once you're in the courtroom and once you're presenting, no one cares. I mean, no one cares if you have a PsyD or a PhD. They're really going to care about your work product, your experience, and where you've worked and things like that. No one asked me where I went to graduate school. That was 35 years ago. Uh, it's not relevant anymore.
Great. Well, thank you, Frank. Thanks for this topic, this presentation. It was great, really helpful information. We've gotten some great feedback here that people are very interested in. Thank you for that. Thank you to everyone who joined us. We appreciate you all joining from other time zones and around the country and even internationally. And if you liked this, we're going to have one more session. It'll be next Wednesday at 5 p.m. You should have gotten information or email, but I'll send you again. It'll be on masculinity and sexual violence. That'll be by Dr. Leguizamo, who is his specialty is on sex offenders and sexual violent work. So we're excited to have him present for us as our third part of the series. And if you're interested in learning more about our programs, we have our open house on November 7th. It'll be virtual, so I'd love to have you join us for that. So thank you again. Thank you, Dr. DiCataldo. Hope you all have a great evening and stay safe.
Thanks a lot. Take care, everybody.